We are very happy to have Judge Michael Kaplan join us today. Judge Kaplan was appointed as a bankruptcy judge on October 3rd, 2006 for the District of New Jersey and designated Chief Judge on May 1st, 2020. He has presided over numerous notable cases, including LTL Management, BlockFi, Rite Aid, and more recently Del Monte and Multicolor. Thank you so much for being here.
It's my pleasure. This is a great opportunity. A little strange.
Yeah, I was.
This format.
I was going to ask you. It's not every day we get to talk to someone on the bench in settings like these ones. So let me ask you, high level, why do you think it's important to have these conversations and for those in the space, I guess, to hear directly from a judge?
I think it's always worthwhile for the bar and practitioners to get some insight into how judges approach issues and what we're thinking in an informal setting when they're not necessarily arguing on behalf of a client or trying to advocate a position, but just more of a exchange of ideas. You don't get to have that often. This is a great format. I have a very limited goal here. It's just to avoid throwing away a 20-year career in 20 minutes. But, I'm sure we could accomplish that.
I'm sure we will. So let's talk about New Jersey. One thing that's obviously it's hard to miss since I guess the first LTL case has been this growing prominence of the New Jersey Bankruptcy Court in large restructurings. I assume the venue switch in LTL was a surprise to you.
It was absolutely a surprise until I did get a call from Judge Whitley in North Carolina, almost apologetically, saying he was sending it up to me and with apologies. But that took us by surprise. We had in New Jersey for decades large cases. We had virtually all of the casinos in Atlantic City at some point, it seemed. We had a series of retail Chapter 11s. One of my favorite, the $20 cupcake from Crumb's Bake Shop. Wonder why that didn't work out well. But sur la table, the kitchen utensils. We've always had large Chapter 11s, but nothing that I would say had more of a national scope or prominence.
So did you anticipate the district evolving into the role it is in now?
I don't think so, although I'm going to be candid. I think the focus on New Jersey securing some of these larger Chapter 11s is a little bit overplayed. We had a lot of activity in 23 and 24 following LTL. 25, we weren't as busy as a lot would like. I was fine with that. And 2026, we started out with gangbusters with all of the LME-based Chapter 11 filings. But I think if you looked at our overall numbers, they still pale compared to a Southern District of Texas or a Delaware. To me, there's a little bit of irony. You go back, I think it's been about 20 years since Professor Lynton Lopucky wrote a book, Courting Failure, in which he ravaged the bankruptcy system, saying there's been rampant forum shopping and every major case is being filed in either the Southern District of New York or in Delaware. And that's just not right. And so since then, we've seen Eastern District of Virginia. We've seen Southern District of Texas. We've seen Northern District of Texas. We've seen New Jersey. We've seen Southern District of Florida. We've had a number of jurisdictions pick up and take on these mega cases, and yet we still have academics and some media who are just not happy. Get the sense he can never satisfy anybody.
What do you think the sophisticated players are looking for when choosing venue, whether it's New Jersey or one of these other courts that you mentioned?
I've said often, and not everybody agrees, but in my view, it is somewhat professional malpractice for those who are responsible for placing cases, whether they be debtors' counsel, whether they be secured lenders' counsel, that don't look to where the case would fit best. And by that I mean what the law is in a particular circuit on certain issues, whether it be gatekeeping or releases uh, or exculpation clauses, what the court's history as far as getting emergent applications heard on a short on a short time frame, whether the courts support mediation efforts in the cases, whether or not the court, how the court addresses U.S. trustee objections. I think it's logical and to me incumbent upon counsel to get a sense of what they can expect. Some aspects they'll like, some aspects they don't. I know our court doesn't try to necessarily attract cases outside of what we would do for any case. But I think it's important for lawyers to know, well, how easy is it to get a hearing on short notice? Because not every jurisdiction does it the same. Or will the judge push for mediation early or not? So I think it's important.
Before we move on to mediation and venue, which we certainly will, I'm
We
curious.
have to?
We'll keep it simple.
Okay.
I'm curious. LTL feels like a lifetime away, but
Yes.
when you are looking at LTL, which involves such novel issues, right, as close to issues of first impression as you can get, I'm curious how much you think about how the appellate court is going, where it's likely to land, as opposed to putting that aside and simply deciding it based on what you have in front of you.
Candidly, I don't think about the appellate courts. They're going to do what they think best. I'll agree with them at times. I won't agree. Early on at baby judge school, we were told by the experienced judges, just because you reversed doesn't mean you were wrong. Just because you weren't reversed doesn't mean you were right. I view bankruptcy judges, we are trial level courts. We are problem solvers. And that's how I approach the cases. I like actually to begin oral argument with a very common phrase, how can I help? The idea is at some point, sometimes making a ruling and deciding a contested issue will help the parties. Other times, pushing them towards a consensual resolution, calling them back into chambers to see if they want to have a conference over the issues helps. The goal is to solve the problems that are presented in that case for a trial level court. The appellate courts are going to make the law. I knew going into LTL that however I ruled, it was not going to be the final word. And it wasn't. Nobody looks at my lengthy, well-crafted opinions. They go right to the circuit opinion. So
I think some do.
it's a process. And I think judges get in trouble when they are too concerned about appellate review. I was asked, actually last week I moderated a panel with new judges from the Southern District of New York, Eastern District of New York, and one of our new district court, bankruptcy court judges in New Jersey. And I was asked what advice you would give. And it would be to take a risk. Don't be afraid of being reversed. If the position you have now that may be reversed 10, 15 years ago may become the adopted approach. You just don't know.
So speaking of taking a risk, your multicolor opinion on venue has generated a lot of discussion, obviously. I think it acknowledged both the practical realities they were just speaking about before, but also some of the criticism surrounding the topic. I guess first, what do you want people to take away from the opinion and the sense of expertise of certain courts being a strength of the system? Do you think that was one of the major points of that opinion?
I think what I was trying to drive at with the opinion is that this problem with the, so-called problem as far as the optionality for law firms and where cases can be placed. I'm not necessarily sure it's a problem. It could be a strength, the flexibility. But if it needs to be addressed, it has to be addressed through Congress. I've told people, maybe defensively, that I am an unelected judge appointed by other unelected judges in the circuit. It is not our role to correct, I don't believe, what Congress, which has had the opportunity for 2 decades to address, we're not to supplant their views. Every issue in multicolor, with respect to the venue dispute, has been brought before congressional committees and debated, and it has never, to my knowledge, even made it to the floor for votes. So I felt I was shocked actually that there wasn't more case law on this, on the issues, on how to interpret the venue statute, and what I saw as conflicting approaches. But the truth is, these don't get litigated. And they don't get litigated, or the rare case gets litigated, when there's, and I think that it occurs when there's really harm done by the placement of the case, harm to the creditor body, harm to stakeholders. In multicolor, not one party, not one stakeholder could point to a prejudice, an impairment of their rights in having the case in New Jersey. It wasn't inconvenient because every hearing was remote. The law, whether if it went to a Delaware court, wouldn't have been any different. It wasn't gamesmanship, at least to me, apparent gamesmanship in where it was filed. And unlike the case that most people cite to, Patriot Coal, where you had tens of thousands of employees and retirees who were being affected and who wanted to participate. That wasn't the case in multicolor. Any party or stakeholder that wanted to participate had the ability to do so.
So generally speaking, then, do you think that the system that is naturally concentrating power and a number of courts, relatively few number of courts, do you just see it as a market efficiency at work at the end of the day?
I don't see it differing from other types of practice in other areas of the law. Nobody will tell me that there's not forum shopping in where the plaintiff's bar brings cases. As I said, all you have to do is look. I live outside of Philadelphia. If you drive on I-95 towards Philadelphia, you see about 45 different billboards of PI lawyers advertising. They want to bring the cases in Philadelphia. They're doing it for a reason, for the trial courts. Patent cases are brought in certain jurisdictions. There are reasons to have cases brought in various jurisdictions. I think what should be notable is that there are more and more bankruptcy courts and districts handling these larger cases than ever were. It's not simply a Southern District of New York or Delaware decision. There are probably close to 10 different jurisdictions. And I personally think all 94 districts can handle these cases. And that would be the goal.
You do. I mean, you end your opinion by being candid that the outcome doesn't entirely sit right with some people. It may actually not entirely sit right with you.
I knew I was getting grief from the opinion. And it didn't sit right because, yes, it was by opening up the bank account, and I think I'm still waiting for my toaster from Connect One for new accounts. It was a mechanism to support venue. Nothing was more obvious than one of the exhibits in the contested hearing in front of me that was labeled venue hook. I mean, you couldn't make that up. So yes, and that of course is unpalatable to have that being so obvious. I fall back on the fact that yes, it seems wrong, but it's clearly provided for by the statute, and that that avenue should be addressed before courts just jump and say it just this. Before courts start using the smell test, I think you have to just apply the statute in the text.
Okay, so moving past venue, are there other are there other aspects of the current practice that may also not sit right with you, whether it's a policy or a practicality perspective, where you feel that your role as a judge is ultimately constrained by the statute?
There's a troubling trend, and it's been it's been exacerbated, and I think people will probably rightly at times point to the judges as being part of the problem. The speed of the cases. It used to be, going back 10, 15, 20 years ago, a Chapter 11 case was understandably an 18-month endeavor. It took time, and you didn't see Chapter 11 cases have to go in 24 hours, 60 days. The practice of having these coercive milestones and deadlines to have bidding practice, to have the bidding procedures, to have the sales, to get a disclosure statement, to get a confirmed plan, I think ultimately rushed the case before before really everyone has a comfort level that what's going to go forward will sustain itself and be feasible. That to me is a problem. The the mounting costs of Chapter 11 are certainly, I think, pricing out certain parties from being able to pursue relief under Chapter 11, just the cost alone. Again, one could say that just it's what the market will bear, but it does seem to be coercive
Do you think that
or oppressive.
the cost of Chapter 11 is being blamed on these on the rise in LMEs, but also perhaps in parties moving to other restructuring regimes outside of the U.S.? Do you think Chapter 11 should think of itself as competing globally, and would the cost be the driving factor for that?
Well, I will say I'm not convinced that the LME activity is any less expensive. You just don't see it. There's no record. It's not in front of the court. There's no fee applications. But the costs and the activity involved with the LME transactions are mount as well. So that's one of the concerns that we see more lately with the LME activity. We all know that just addressing the balance sheet isn't the problem. You have to address the operation fixes for a lot of these companies. Everybody discusses that. That's not debatable. What I think doesn't get enough study, unfortunately, is the condition of the company once it goes through the LME and now is in its eventual Chapter 11. Is it in a worse position? Because right now you've seen credit agreements. Any holes in the credit agreements have been fixed. Any it's all even more leveraged up. You see cases that are basically just carcasses now coming into Chapter 11 after an LME. So the condition of the Chapter 11 debtor, I think, has worsened as a result of some of the LME activity. It's just doesn't have the resources, doesn't have the liquidity. And we don't see competitive dips. We don't see the tools that are there after an initial LME transaction.
What do you think of the argument on the other? You hear sometimes that the rise in Chapter 22s sort of prove the opposite, that Chapter 11 may not be as useful or as efficient as it could or should.
I don't accept that. I think Chapter 22s often serve a different type of function. A lot of them are because of events that are outside of the party's control or expectations. I think part of the problem was the speed that we talked about. You might not have the Chapter 22s if you weren't moving so quickly with the initial Chapter 11. In essence, an LME that's followed by a Chapter 11 is really just a Chapter 22 in any event. And there can, like in Rite Aid, there was a different goal, different issues being addressed in the Chapter 22 that weren't addressed in the initial filing, and you needed both in order to have a successful disposition of the case.
Okay, so one response to some of this efficiency and cost concerns is the emphasis on consensual resolutions. And that naturally raises questions about the court's role as a facilitator of the settlements. And obviously, Chapter 11 in many ways is designed, right, for this negotiated outcome. And I don't need to mention the names, but we know some of your recent cases have drawn some attention for your role serving both as a presiding judge and as a mediator. I guess just your opinion as to how you view the role of the bankruptcy judge in promoting settlements in the system, and how active do you think a bankruptcy judge can or should be?
It goes back to what I said, our role as trial courts are there to solve problems. And I've been shocked by the attention, the issue as far as my mediating cases that are before me has gotten, because in my view, it's just a label that's really underlying the issue. Bankruptcy judges going back to Burton Lifflin and Duberstein and going back 20, 30 years up through former judges like Bob Drain have always brought parties into chambers in an effort to settle matters when it's consensual. When more often than not, and in each of my cases, the parties have asked for my assistance. Settlement conferences get no attention. Nobody would say boo. Federal judges do it all the time, district court judges, apart from bankruptcy judges. It's not unique to bankruptcy. State court judges hold settlement conferences. It's a label. What brought, I think, attention to this issue, unfortunately, was that these are large cases with very experienced counsel from the largest law firms who wanted to make sure that their clients' rights were protected, and they insisted on putting together a 30-page mediation order. You don't see that with settlement conferences. It was all of a sudden a mediation order hit the docket, and they had my name in it. Well, the mediation order was there to protect their respective clients regarding privileges and information and disclosures. It wasn't for my benefit. It's unnecessary. I've got all the immunity I need. But for that mediation order, it wouldn't have been an issue.
Do you think practitioners value the approach? How do they think of it?
As I said, all these requests for my involvement were consensual. There are times when, to save costs, to save time, the parties will ask the presiding judge to get involved. And if it's consensual and all parties sign off on it, it makes sense. Now, there was an argument that's been raised, but the bankruptcy judge should not see and be able to hear certain evidence that may come in during a mediation session. And I kind of laugh, because we are the trier of fact on every contested hearing. And every hearing, there are evidentiary issues and objections, and I am overruling objections, and I am hearing evidence that is not coming in. So whether I hear it out in the courtroom or I hear it in chambers or in conference rooms, the parties have a trust that the court can separate its tasks in adjudicating a matter versus settling. But as a practice, I don't jump at the chance, and I don't think any judge jumps at the chance to mediate a case that they're presiding in right from the get-go. I know we have a mediation panel in the District of New Jersey. I like to have all the lawyers wet their beak and You can go to the mediation panel. Let lawyers earn a living. If not, I ask colleagues down the hall to hear it. But there are certain situations where there are no colleagues available, where time is pressing, or the parties have a comfort level with the judge because the judge knows the history, knows the issues, knows the parties, and they're willing to take on the risk and with the hope and expectation that the matter can settle. And I think 90+% of the time it does.
So it's fair. Do you think of it as a practical, pragmatic approach to the system?
I do. Everybody understands that for the most part, contested matters settle. These LME-based Chapter 11 cases that we've had in 2026, virtually all went through mediation and they all settled, as opposed to being litigated in the state courts for a year and a half.
Do you ever worry, though, that there are important legal questions out there that go unresolved, that there's fewer opportunities today for courts to fully engage, and maybe even selfishly to just not be able to address interesting questions?
Well, I look at the number of opinions my chambers has generated in the last few years. There's no shortage, and we address the issues. Often I tell the parties, I'm actually the last person who should be deciding these issues. I'm the least equipped person out there to necessarily weigh in on some of these restructuring issues and LME issues. They're all better versed in it, have more of a history with the issues, have a better technical understanding. I don't necessarily think a bankruptcy judge, just because they wear a black robe, is the best person to be making these decisions if they can reach a resolution on their own.
Okay, so last question, after all we've discussed today.
God, it's been a long 20 minutes.
Oh, I'm sorry. We'll end on a very positive note.
Oh.
What do you think the Chapter 11 system still does exceptionally well today?
I think in certain situations, I know it's there to protect the stakeholders who aren't necessarily in the room. That there's a lot of negotiations going on and out-of-court restructurings where there are going to be excluded groups. And I think the Chapter 11 can offer the opportunity at times to protect the interests of those who aren't in the room, so to speak. Then again, sometimes those who aren't in the room had the option to be in the room and could have paid to be in the room, and that's not there for us to protect them. But in a lot of situations, we're there for those who need the door opened to participate.
Thank you so much, Judge.
This was great. Thank you.